Your Florida HOA may be telling you that you can't do things that they legally have no power to stop you from doing. Yep, and some of the things that Florida law protects you from might surprise you. Florida HOAs have real authority. When you go to buy a home in an HOA, you are agreeing to abide by the restrictions set up for that community. But an HOA does not get unlimited authority simply because it's an HOA. Florida law places boundaries around that power, and some of them are surprisingly specific. So let's talk about a few situations where you might hear no from your HOA and how Florida law may have something else to say about it. You decide you want to make an exterior improvement to your home. You check the HOA documents and they require you to submit for an architectural approval. Maybe you are looking to paint your house, replace your roof, change your fence, add a patio, install shutters, or make some other exterior improvement. You submit the application to your HOA or Architectural Review Committee. They respond, no, you can't do that. Per Florida Statute 720.3035, the HOA's architectural authority over the location, size, type, or appearance of an improvement must be specifically stated or reasonably inferred from the declaration or from property authorized published guidelines or standards. These standards must be applied reasonably and equitably to parcel owners. The Architectural Committee does not simply get to reject something just because the members personally don't like it. And believe me, there are plenty of cases out there where this was the case. Y'all, there's a reason why these laws were put into place. If the HOA denies an architectural application, Florida law requires written notice identifying the specific rule or covenant relied upon and the specific aspect of the proposed improvement that does not comply. So if your HOA tells you no, your next response should be, show me where it says that. That's not necessarily you being difficult. If they've denied your architectural application, Florida law actually requires them to identify what rule they were relying on. So there is a new rule that just came into play that we need to be aware of. Suppose an HOA says it will not review your application until you first obtain the required government building permit. But the new law says, effective July 1st, 2026, per Statute 720.30351-C, provides that an HOA may not require issuance of a government building permit as a prerequisite for its architectural review. Now, let's be clear. This does not mean that a homeowner can skip the required city or county permit. I mean, come on, y'all, you have to be legal. But it does mean that the HOA cannot require the government permit to be issued first before the HOA performs its own review. But issues with an HOA is not always related to building something. So let's say you want to put a clothesline on your property, but your HOA says absolutely not. Clotheslines are not allowed in this neighborhood. Well, Florida law has actually been thinking about your laundry too. Florida Statute 163.04 protects clotheslines along with solar collectors and other energy devices based on renewable resources. Deed restrictions, covenants, declarations, and similar agreements may not prohibit or effectively prohibit clotheslines. The legislature stated the policy is tied to encouraging renewable resources and conserving and protecting land, buildings, and resources while avoiding measures that increase the cost of owning and operating property. So let's think about that for a minute, y'all. Your electric dryer uses electricity. That costs you money and it uses resources. The abundant Florida sunshine hanging over your backyard is absolutely free. And come on, who doesn't love the smell and feel of fresh sheets on the line? Florida Statute 720.3045 generally prevents an HOA from restricting the installation, display, or storage of certain items when they cannot be seen from the property's frontage, an adjacent parcel, an adjacent common area, or a community golf course unless prohibited by general law or local ordinance. In this statute, clotheslines are specifically listed as an example. Florida gives clotheslines some pretty strong protection. That does not mean I'm going to tell you to go stringing your underwear across your front porch and telling your HOA to toss off. It still has to follow the rules set forth in the law. And I'm kind of interpreting that to be out of sight, out of their business. What about RVs and boats? Yeah, this is one of those very popular ones out there in our sunny state. Let's say you own a boat or an RV and have room to store it behind your house, behind a fence, or somewhere else on your parcel where it is not visible from the location specified in the statute. But your HOA says, our rules don't allow for boats or RVs to be stored on residential lots. Well, that's not what Florida law says. Florida Statute 720.3045 specifically names boats and recreational vehicles among its examples. If the item cannot be seen from the property's frontage, an adjacent parcel, an adjacent common area, or a community golf course, the HOA generally cannot restrict the owner or tenant from storing it there, unless general law or local ordinance prohibits it. Now, I know some of y'all are out there going, wait, what? Yeah, if you've got a boat or an RV tucked away out of the specified lines of sight, don't automatically assume that your HOA rules that say no RVs ends the conversation. Do your own research on it. Talk to an attorney if you feel the need, but don't let it end just because your HOA says no. Now let's talk about some real garbage. Y'all know about this one. It's a hot topic in HOAs. The garbage police love to write nasty grams and issue citations for this one. So let's say the garbage pickup was yesterday. You got busy. The garbage can is still sitting at the curb or at the end of the driveway this morning, and the HOA wants to fine you. Your garbage receptacle wasn't removed after collection, and they smack you with some big old fine. Well, once again, boys and girls, this is not what Florida law allows for. Florida Statute 720.3057 says that an HOA may not impose a fine or impose a suspension because the garbage receptacle remains at the curb or at the end of the driveway within 24 hours before or after the designated garbage collection day or time. Now, it's important to note that this does not necessarily prevent an HOA from having a rule about garbage cans. Rather, it specifically limits the HOA's ability to fine or suspend a homeowner for this conduct during the protected statutory window. So if you get a notice of a fine stating that the trash came yesterday morning and the can is still there this morning, before you write that check, you might want to take a look at the clock. The sad truth is sometimes we have to teach HOAs what's allowable and what isn't. Now, here's a fun one. Let's say you leave your Christmas lights on your front porch all year long. There's a song in there somewhere. And your HOA documents say that holiday decorations must be removed by January 10th. Well, January 11th arrives and good old Clark Griswold is still alive and well at your house. Your HOA wants to fine you and send you a nasty gram about it. Can the HOA establish a deadline for removing holiday decorations? Yes, they can. But can it immediately fine or suspend you simply because you missed that deadline? Well, let's see what the law has to say on that subject. Under 720.3057, an HOA may not fine or suspend an owner for leaving holiday decorations or lights up longer than permitted by the governing documents unless the decorations remain up for more than 1 week after the HOA provides written notice of the violation. The sequence matters here. HOA deadline passes, decorations remain. HOA provides written notice, statutory 1 week period becomes relevant. Now let's be clear here, this is not a blanket extra week after the HOA's holiday deadline. So yes, they can tell you that Christmas is over. Apparently Florida just requires them to give you a little more time to emotionally get over it. And if you're a Christmas junkie like my husband is, you might actually need that grieving time. Some of these are funny, but this next one isn't. Let's say you decide to upgrade your home's hurricane protection, and you submit the required architectural application. The project might involve impact-resistant windows or doors, permanent or roll-down shutters, a qualifying roofing system, reinforced garage doors, polycarbonate panels, an exterior fixed generator, a qualifying fuel storage tank. The HOA does not like the proposal or wants to deny it. So what can you do? Well, Florida Statute 720.30356 requires that the HOA Board Architectural Committee to adopt hurricane protection specifications. These specifications may regulate matters such as color and style and may require adherence to existing unified building scheme for exterior appearance. So hurricane protection does not mean a homeowner may install absolutely anything without regard to the HOA's lawful specifications. Here's where Florida draws the line. If the homeowner's proposed hurricane protection conforms to the HOA's adopted specifications, the HOA may not deny the application. This hurricane protection provision applies to all Florida HOAs regardless of when the HOA was created. We live in Florida, y'all. The HOA can have reasonable standards for what your hurricane protection looks like, but if you've complied with their specifications, they don't get to simply tell you that they don't want you protecting your home. Now, before everybody runs to the comments and tells me how horrible HOAs are, I'm going to say something that some of you aren't going to like. Maybe, just maybe, having an HOA isn't necessarily a bad thing. You see, there is another side to the community: restrictions, standards and maintenance, amenities, enforcement. Y'all might not want somebody telling you what you can do or can't do with your property. I get that. But you might also not want your neighbor's old 1978 Project Camaro sitting in the front yard on blocks for 4 months. Trust me on this. I've had the neighbor from hell living next door. It brings down your mood every time you look over there, and it brings down your property value because nobody, and I mean nobody, wants to buy a nice house that has that going on next door. That's an instant buzzkill for your curb appeal. Trust me on this. And without an HOA, there is absolutely nothing that you can do about it. But I digress. The larger question is not simply HOA versus no HOA. It is whether this HOA has reasonable rules, operates properly, and fits the way that you want to live. And this is why if you've automatically been eliminating every HOA neighborhood from your home search because you were afraid you'll lose all your freedom as a property owner, I wouldn't be so quick to do that. The better question is not simply, does this house have an HOA, but rather, what does this HOA actually require? When you're buying a home, your buyer due diligence of the HOA should definitely include reading the governing documents for yourself. Trust me on this, guys. Do not leave it up to somebody else's interpretation of what those HOA governing documents say. One person could interpret it one way, and you might interpret it another. Same thing with understanding the restrictions. You need to read them for yourself and understand them for yourself. Review the fees. Look for current or potential assessments. Understand architectural and approval processes. Decide whether those particular restrictions protect things like your value or interfere with how you want to actually use the property. The goal is to make an informed decision. This is not an automatic HOA good or HOA bad reaction. So I'm curious, guys, would you rather live in an HOA that can tell your neighbor to get the Camaro off the blocks, even if that means them having some say over what you do with your property? And if you've ever had an HOA tell you something completely ridiculous, I really do want to hear what it was in the comments. You see, I've been in this business for 33 years, and I still think it's my job to keep on learning, because the more I know, the better I can help my clients make smart decisions. And by the way, if you're looking to make a real estate move soon, reach out to me. I'd love to help you with your goals. In the meantime, be sure to follow me for more great Florida real estate conversations.